Hello, everyone. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, your host for today. And before we move forward with today's webinar, I have this important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Everyone, welcome once again to another insightful session on Immigration and Jobs Talk Show. And it's truly an honor to have you join us wherever you have joined us in. So, we are streaming live right now on YouTube, LinkedIn, Facebook, and X. And please feel free to comment wherever you're watching if you have any questions with regard to immigration and especially about on our topic for today. Yes, so it's going to be another engaging topic, and we are going to dive into this topic, which is like looking back at the year 2024. I know this year has been really monumental, for U.S. immigration, whether it's policy changes, evolving priorities, and even impactful decisions that have reshaped the landscape for businesses, families, and even individuals, in the system. So, to help us decode and reflect on what truly shaped US immigration this year, I'm really thrilled to have our guest today, the renowned attorney and founder of our immigration law practice, Attorney Prashanthi Reddy. Yes, with her expertise in business immigration, family based petitions, and legal strategies of diverse industries, she has been a guiding light for many, who are going through this complex process of immigration. And Prashanti, thank you so much for joining us today. It's really good to have you back on our show.
Good to be here, Nipasa, as usual, and looking forward to another interesting show.
Absolutely. And I think we should just jump right in and explore how 2024 unfolded for US immigration and its implications for the future. So, yeah, I think let's go ahead with our first question that I have for you. And that is, what were the major impacts of 2024 H-1B visa lottery changes on employers and foreign workers?
So there've been um, there's been a lot of impact with reference to H1Bs, mainly in October of last year. Um, Biden published a modernization rule, and parts of it was implemented this year in 2024. So they implemented the part with reference to the lottery. So they changed the lottery this year, and they made it so that beneficiaries who file more than one registration will be counted only once. So that was a major change in the H1B lottery process. And the rest of the regulation is still pending. And AILA has been actually, I just saw recently a post from AILA saying that they have urged the Biden administration to finalize the rule on modernizing H1B regulations, H1B laws. And we're hoping that we will see something before the administration leaves to give way for the new administration, but let's see what happens. But this modernization of H1B requirements regulation is published in the Federal Register, and they're waiting for the comment period. As I said, only part of it was implemented with reference to a couple of parts with reference to duplicate registrations and also with reference to another registration policy. So if people file registrations um, using some kind of a fraud, then USCIS is able to now go after them and will cancel their registrations. And if they file, like for example, a registration for a person more than once, so if they do two registrations for the same person, then they will cancel that registration. So they've put in more regulations and formalized that rule that will allow them to then cancel those registrations. With reference to the pending law, there is a lot that has to be done. First of all, they are finalizing some things with reference to the definition of specialty occupation. They're allowing for a wider range of degrees to qualify for a particular position, and that was a big hindrance for filing H1s in many positions. So some positions might open up for a specialty occupation, which previously USCIS would not approve those positions. Just to maybe give you a few systems analysts and some others IT related, maybe computer programmer as well. Other IT related positions which have a lower salary range. And previously, these jobs could not be approved, or these H1s could not be approved because the job required a bachelor's degree in, say, computer science or engineering, and they said that engineering was too broad a degree, and now they're refining that to um, kind of give us a better understanding of what is a specialty occupation and what is not. Also, there were some um, regulations with reference to F1 cap gap status. Now, presently, the F1 cap gap is will be valid only until October 1st, or the approval of the H1. They have decided to extend that to the next year, the next lottery season, the next cap season, April 1st. So, if a person is the cap gap is basically if the person was on a particular status when the H1 was filed, they continue to be in that status even though their OPT might have expired, or maybe they finished their school, but they continue to artificially be in that status so that they don't have to extend that if there are any delays in their H1B. Um, we saw under the Trump administration increased denials of petitions. They went up by 24%, and the RFE rate was in fact 60%. But in 2024, we have seen really lower denial rate of less than 2% to 2% or 3%, and even an RFE rate has been much lower in 2024. So that is really a good movement going forward. Also, we are worried about what will happen in the future because, as I said, there is a lot that might happen under restrictive salary requirements, increasing the requirements of the salaries under the Trump administration. So again, the whole idea is to try to get the Biden administration to finalize the regulation that they have for H1Bs so that it'll be much more difficult than for the Trump administration, remove that or make changes to the regulation moving forward. So that's a little bit about what happened in 2024 under Biden.
Yes, we saw a lot of changes and good changes, I think we can say, no, Prashanti? And
Yes, yes.
yes, the beneficiary-centric H1B petitions as well. So, very much to keep in mind. Some major changes, actually. Yes. Thank you for highlighting them, Prashanti. And I'll quickly say hi
Welcome.
to Sneha. Hi, Sneha. Thank you so much for joining us. Yes, we will address your question a little later in the show, so please stay with us, all right? And
Also,
moving ahead, Prashanti, I have,
Nipasa,
sorry,
Nipasa, I
yeah.
wanted to add that another change that we saw was with reference to processing of the H4s and the H1s together. This was, of course, because of a lawsuit, and because of that, there was a settlement agreement whereby USCIS agreed to process H4 and H4 EAD applications, H1 applications. This really impacted H4 EADs in a positive way, which allowed them to continue working. Also, we saw automatic extensions of H4 EADs. So if your EAD expired and you filed it on time and your I-94 is still in process, I-94 is still valid, there's an automatic extension of 540 days, I believe, on the EAD. So we saw that extensions also take place and continue. So that, that was, again, big impact for H4 EADs.
Right. Right. Thank you so much, Prashanti, for highlighting that as well. Very, very important change that we saw in 2024. Now, moving ahead, I have another question, and this is, in 2024, we saw an increase in visa processing delays as well. So, what were the main causes, and how did it affect applicants?
So we have to look at 2024 in relationship to 2023 and the years before, right? So if you look at it in
Yes.
relationship to the previous years, the visa processing times they've actually tried to improve the visa processing times, and we've seen improvement compared to the previous years. Yes, there is still a delay, but compared to the previous, the delay has been used. And the reason we've seen that this has happened is because they have extended the waivers for the interview visa interviews, right? So they have waived visa interviews in certain situations where you've previously been on a visa previously and you've filed, you've uh, gone to renew your visa within a certain period of time. We've seen that USCIS has said that your interview will be waived, and because of this law, they've been able to improve processing times. Under this law, basically, if you are eligible for it, mainly if you have filed a visa before and you have a visa stamped in your passport, then you can apply for a. When you apply for a visa, they will most probably do a drop box, which means that they will ask you to put in all your documents, submit all your documents by Dropbox to a Dropbox center, and then they will process your case. If they need to call you in, then they will do administrative. They will change your processing to administrative processing, and they may call you in for an interview, or they will just approve your case based on the documents that you submitted in the Dropbox. So, because of that change, that has really improved the processing times for visas. And mainly I'm talking about H-1B visas, of course.
Mhm.
But they're still, processing times are still very delayed. Non-immigrant
Mhm.
work visas are a little better. And the reason for this is basically the what we're seeing with reference to COVID. We are still seeing impacts with reference to COVID and the backlog that was generated due to COVID, and especially with visitors visas. So this has affected people obviously because they have to apply. They have to apply for visas way in advance. So if there's an emergency, they really cannot come into the U.S. So if you're a parent and you have a child who's experienced some kind of an emergency and needs your help, if you have not applied for a visa, then you will not be able to come in. So my advice to families is to apply for a visa and keep it, whether you need it or not, whether you have plans to travel or not. Just apply and keep it so that if there is an emergency, you will be able to use your visa and travel in. So that's some of the changes that we've seen with reference to visa processing.
Right. And talking about it, when these changes had suddenly occurred, there was confusion and there was also rejection in the visas, right? With reference to Dropbox, I mean, when there were sudden updates and also the fee changes as well. So many things also led to, I mean, visas being rejected or, denied.
Right. So the fee change, that was a big, so that's another, I guess we can say another change that happened in 2024 is all the fees changed, number one, and
Yes.
also all the forms changed with reference to USCIS at least, and the fees with reference to Department of State as well. So because of that, of course, there was confusion. Also, they changed the addresses. Again, I'm talking about USCIS now, not so much Department of State. They changed the
Mhm.
addresses whereby you had to send the forms, they send the fees, change the fees, they send the form, they change the forms itself. So there was a lot of confusion and denials and rejections because of that.
Right. And which also caused processing delays. So, yes, thank you so
Correct.
much for highlighting all of that as well, Prashanti. Moving on, now I have another question, and this is How did the public charge rule enforcement in 2024 affect green card applicants and their families?
So again, we have to give some context so that people understand, number one, what is public charge, and number two, why did we see a change after the Biden administration came in? So a little bit of history. Public charge rule is a rule which is applicable to everyone that files a green card. You have to show that you will not be a public charge, meaning you will not take um, money and health insurance, free in the health insurance, etc. Mainly money from the government for sustenance. That's what the public charge rule was previously, and the way you show that is for employment-based cases. If you are on a H1, have an I-140, and you're filing for your family as dependents, then you're filing an affidavit of support to show that you will take care of them and take care of their needs, and they will not be a public charge, right? And there's also a form that has to be filled out, which is part of the 485 now, with reference to some public charge questions. So previously, it was an easy process, and as long as you had an affidavit of support and you did not use public assistance before, you would not be subject to the public charge rule. Under the Trump administration, they made the public charge rule into much bigger uh, and increased the scope of the rule really. And they had a completely, like, 3 pages information that had to be filled with reference to the charge rule. And sometimes we were submitting 300, 400 pages of documentation with as required by the public charge rule, the tax returns, the insurance policies, health insurance policies, life insurance, etc., etc., everything. They were asking for all this information, and then the officer could then make a subjective decision based on whether they thought that the person would become a public charge or not. So even in instances, for example, where you're filing a family-based petition, where you're processing your parents' petition, your parents might be retired and they have no source of income, even though you're submitting an affidavit of support, and even if they have not taken any public assistance before, they might have been considered to be a public charge, and then the green card might have been rejected. Also, they changed the definition of what kind of public assistance, or the scope of what kind of public assistance could be taken to be considered a public charge. And they said that everything, including health benefits, health insurance, if the woman was pregnant, child health insurance, food stamps, anything could be considered public assistance. Now they have narrowed down the definition of what public assistance they will look at to consider whether you're a public charge or not. And they said only SSI, meaning money that you have taken from the government to sustain yourself, or long-term institutionalization, meaning if you have been um, if you have been admitted into a hospital or mental institution for a long period of time, or a old age home, for example, but with the help of money that you've received from the government, then that would be considered to be a public charge. And food stamps, other kinds of health insurance is no longer considered to be a public charge if you've taken any of that. So under the Biden administration in 2024, it's been pretty smooth sailing with reference to public charge. I have not seen any denials with reference to it, because the scope of public charge rule has been brought back to the previous how it was previously. The form also has been changed, and the number of questions with reference to this public charge rule have been decreased. And so, yeah, it's been pretty smooth sailing with reference to the public charge law rule enforcement.
Thank you so much, Prashanti, for highlighting that. And yes, those were a few public charge. Sorry. Yes, public charge rule enforcement in 2024 that affected green card applicants and their families. Now, moving on, Prashanthi, what steps did the US government take in 2024 to address the rising number of asylum seekers at the southern border? And what changes can we expect in the future?
So with reference to the border, I mean, we know that they took over from the Trump administration, and with under the Trump administration, the Trump administration um, brought into effect Title 42, used Title 42 basically to restrict asylum cases, and there were pretty much no asylum cases processed at the border. This Title 42 allowed, it's an old law written in 1944 and very vaguely written at that, which allowed the government to limit border crossings for public health reasons. So because of the pandemic, Trump administration uh, used this Title 42 to limit the people coming into the US and virtually blocked anyone from seeking asylum and sent everyone back based on Title 42. Um, Now, the Biden administration removed this Title 42 very recently, so they continued with the Title 42 as well. But they removed that very recently, I think last year or beginning of this year. And under the Biden administration, what they did is they transitioned to another program called CBP-1. So they started a CBP-1 app for asylum appointments, so that the asylum appointments were available, but were they're limited every day. So only a certain number of people could apply for asylum every day. The ones that and they had to apply on that app, and those asylum seekers would be processed. Um, and of course, under the Biden administration, they've promoted keeping the family together. So they removed, I mean, the Trump administration themselves removed it in his last year of separating families and, detaining them separately, and which led to, parents losing their children and CBP having to, then find the parents. And that didn't happen for many years, even after there were some kids who were still uh, in detention and or put into uh, put in with other families because they couldn't find their family. So all that was brought back to normalized under the Biden administration, and they removed. They continue to follow this system whereby the entire family would be detained together, or children would not be detained. So they stopped the process of detaining children separately from their parents. So that continued to happen in 2024 as well. And they, as I said, bought this change, and they allowed limited asylums. They still didn't, asylum was still very restricted under the Biden administration this year, but they allowed limited asylum. What to expect next year or moving forward? We can expect that the border will again be restricted. This is, I guess, only with reference to the border, right? The question is. Um,
Yes.
yes, so we can expect Title 42 might be brought back in, or some other kind of restriction. Under previous Trump administration, there was also a Muslim countries restriction. So people who came from the 7 countries were not allowed into the country if they were in those countries. So we can expect that to come back in. Um, we can
Right.
expect, we know this because um, there has been appointment of Tom Homan, who's now the border czar, and he was the one who started this zero tolerance policy, immediately prosecuting everyone found to cross the border illegally, and he was the one who detained the parents separately from their children. Um,
Right.
and so we can expect maybe that to come back again uh, because he's been appointed again as the border czar. And Stephen Miller as well, who is the White House deputy chief of staff who is known to be restrictive with reference to immigration policy. He holds a restrictive view. And we can also see restriction in other departments as well. But yeah, with reference to the border, yeah, we can expect again Title 42 restrictions for people from Muslim countries, um, and restriction or almost stopping asylum at the border. And of course,
So true, so true.
the border wall again. They'll start again construction of the border wall. And also, they have said that they want to bring in the army and increase the number of border patrol staff to, patrol the border. So these are the few things that we can expect will happen.
So true, Prashanthi, and thank you so much for highlighting all of these things that we can expect in the coming year, and also looking back at 2024, the changes we saw with regard to the southern border especially, including and now, yes, moving ahead, of course, you were talking about the physical wall as well. So we can expect a lot of that, and we have been discussing over and over in our shows as well what we can expect in the year 2025 with Trump's second reign. And yes, not forgetting Tom Hooman and Stephen Miller going to make it even harder, I guess, the whole of Trump's team. Yeah. And I'll quickly say hi to Neha and also Rajesh. Thank you so much for your questions. Please stay with us. We are going to address them very, very soon. And moving on, Prashanthi, how did the changes in labor market conditions in 2024, especially in tech and healthcare, impact the demand for work visas like H1B and O1?
Well, we did not see an impact because if you look at the number of H1s registrations filed, they were the same as the previous years. Um, Not accounting for last year, which was an exception because there was multiple registrations filed. But number of single registrations, really, we didn't see any change. I guess the reason we didn't see any change impact on the H1Bs is because these H1s, the people are filing these H1s for the following year, and they expect maybe the market to get better. Um, so the demand has not decreased for H1Bs. But yes, we know that there have been a lot of layoffs. So, with reference in my immigration practice, I have seen a lot of requests for change of status from H1 to F1 or H1 to B2. A lot of cases I've seen recently, people asking for these change of status applications to be filed, wanting to file them. And this is despite the 60 days grace period rule, which basically shows that they're not able to get the job in the 60 days grace, and now they're having to either leave the country or they're having to file a change of status to an F1 so that they can go back to school and then file for a H1 again once the market becomes better. So we are seeing a lot of people stuck because the market is bad and moving to different statuses, B2, F1, etc. Um, but we didn't see again an impact on the H1B filings. We saw that the H1B cap got over this year as well, just as it had the last few years. The number of cases being filed after the registration also, um, you know, all the cases have been filed obviously because they did have another lottery, but that lottery after they had not another lottery, but they picked few more cases from the previously held lottery. Um, so we know that all the H1Bs were used up. So I don't see maybe if I mean I don't see impact on the number of H1s filed because then they would have had another lottery, right? If the H1s were not used up. So they only had two lotteries. So that's why I'm thinking that the demand was really still there because it's usually the H1s are filed for the following years. So unless
Right.
the labor market remains low for 2-3 years, then we'll see maybe a lowering in demand of number of H1s that are filed. Um, yeah.
Yeah. What about O1?
O1 as it is, there are not many O1s filed because not many cases are eligible for an O1. An O1 is
Hmm.
the eligibility is same as an EB1. So you have to have extraordinary ability or exceptional ability. And not many people qualify for that. So it's not, O1s are not filed en masse like the H1s are. But the
Right.
demand, to answer your question, demand for O1s is always high, meaning that people always want to file for an O1, but they can't because they don't qualify.
They don't
So
qualify.
yeah, so while they want to, and in that way the demand is high, the number of approvals or the number of cases that qualify still remain low because we don't have that many people with extraordinary ability.
Right.
But compared
Thank
to
you so much,
previous
Prashanti.
years, compared to previous years, I would say that a lot more people are finding filing O1 out of desperation, because of the
Hmm.
cap situation, because they want to be in EB1. So there is a lot more filing of the O1. A lot more people are trying to file and trying to get approved under O1, trying to go into the research field, or publishing articles so that they are extraordinary, or they can show that they are extraordinary. So I would say yes, the demand for O1s is going up. It's just that it won't go up as much because there are not many people qualified.
Qualify for it. Yeah. Thank you so much, Prashanti, for highlighting those very important points that we saw in 2024. And moving on now, let's go on to the next question. And that is, what were the most significant changes to family based immigration laws in 2024? And how did they affect processing times and eligibility?
So there's one recent change that it's just a day or yesterday or day before which I saw USCIS made with reference to family-based and employment-based immigration, is that they have said that the medicals so have to be sent along with the 485 application. So in the previous times, what would happen is applicants would file 485 and then send the medicals later after they got an RFE. So USCIS wants to reduce the number of RFEs for medicals because that is expensive for them and time consuming. And they now want the medicals to be submitted along with the 485. And if these medicals are not submitted, then they are saying that they will reject the entire 485 application and send it back along with the fees and everything. Then you have to resubmit it. So it'll be rejected from the mail room if you don't send medicals. That's a very significant change in family-based immigration. So please, if you're filing a 485, make sure that you submit the medicals upfront along with your application for all the applicants that are filing. Otherwise, your case will get rejected and sent back. And the problem is, if it's a deadline, if you're falling out of status, these cases are not sent back until a month later, and you might not be able to refile. So keep that in mind. So that's one significant change with reference to family-based immigration. But otherwise, it's been business as usual in 2024. Um, as I said, with the modified public charge rule, the process has been much smoother. The number of documents that we have to submit are much lesser than under the by Trump administration. Um, and processing times are as is. I mean, USCIS is trying to improve processing times, but I think the processing times are similar or the same as they were last year. It is taking 12 to 18
Right.
months for them to process, sometimes longer when there is an issue. Um, the good thing that they have done in this year, I think, is they have tried to decrease the number of green card interviews for both family as well as employment-based cases. Even
Mhm.
for spouse-based cases where interviews used to be compulsory almost, I've seen some spouse-based cases getting approved without interviews. So that has reduced the processing time uh, for family-based cases. They've reduced the number of interviews, but in general, I think processing times, remain the same, about 12 to 18 months. I haven't seen any significant other changes. RFEs are still being sent as needed.
Yes.
Um, and sometimes, even when not needed, when you submit a birth certificate, they will still ask for the birth certificate. I have no idea why, but yeah, it's business
Mhm.
as usual.
Mhm. So true. I mean, we always look forward for the visa bulletin and really try to see if the dates have moved. But every time, I mean, especially last year, I mean, this year when we look back, we were whenever we had visa bulletin updates, we were always disappointed that there was not much movement in any of the dates. So I think, yes,
Correct.
thank you for highlighting that as well. Yeah, I think we'll just address some of the questions from our audience, then, we'll come back to our questions again. Let's take up Sneha's question. In your opinion, what's been the biggest legal challenge for immigration in 2024, especially with all the changes happening under the current administration? Very.
So yeah, so under 2024, there's been some changes made. Um, so we might as well talk about that now. Um, so one thing change made was the parole in place. Biden
Mhm.
administration rolled out a new initiative aimed at um, keeping families together. So previously, if U.S. citizens had to file for their family members, if the family members didn't enter legally, you could not file a green card for them. So you can't file a family-based case. So for in those cases, they had to leave, apply for waivers, and they couldn't stay in the country. Now they've created a temporary measure called parole in place program, and the new action allows eligible applicants to apply for the green card in the United States, avoiding, separation in families. So they'll allow them to have some kind of status while they're in the country, so that they don't have to leave, and they'll also give them EADs. So as long as there, of course, there's some criteria for this. The person must have resided in the U.S. for 10 years or more. um, they must be legally married to the U.S. citizen and meet uh, all the other, legal benefits. So if this happens, then so eligible individuals can apply for a green card over a 3-year period from inside the U.S. They can get work authorization for up to a 3-year period. So this kind of affected about 500,000 spouses and about 50,000 children of U.S. citizens. And it was there was a lawsuit filed also against this parole in place. But as of now, it's still in place. But again, with the Trump administration coming in, I think they will remove this parole in place because it was done through an executive order. The other thing that they've updated is, but we don't have much information on it, is they call it the easing of the visa process for US college graduates, including Dreamers. So in some broad language, they've talked about easing uh, getting of the visas for college graduates, as well as, so for people who are on F1 when they're going back, and, getting visas, or people who are coming to the US on F1 visas. They're trying to ease getting of H1s or getting of initial visas, I think, for these people. But there are limited details with reference to who benefits, how they benefit. But so far, what we know is that individuals, including DACA recipients and other dreamers who have graduated from an accredited US institution and have a job offer in hand, will receive their visas more, not said how or when. Also, they focused on college graduates with high skilled job offers, right? So people who are
Yes.
have their masters here and have designated to any of U.S. employers to retain talented people. So they're for those people also they're offering an easy way of getting a visa. This initiative
Mhm.
ensures that U.S. educated people will remain in the U.S. so that they don't have to leave the country and benefit the U.S. economy.
Yes.
But they're not actually given much information on it, and it seems to be too little, too late, because under the again Trump
Great.
administration, again it'll go back to square one. So unless they
Yes.
pass a regulation, I don't know if they have the time to do that or not. But they have indicated that you know this is what they want to do.
Right. Right. Thank you so much, Prashanthi, for taking that up. And Sneha, thank you for your question. I hope you've got your answer. Let's move on now to Neha. This is on YouTube as well. Prashanti, Neha is asking, how do you think the increasing use of artificial intelligence and machine learning in the US immigration system will change the way immigration attorneys practice law? And what steps can attorneys take to stay ahead of the curve and effectively leverage these technologies to benefit their clients?
Is Neha an attorney? I was wondering um, from
But
her
I think
question.
she
But
is pro
uh,
AI fan.
yeah, right. So that's up to each individual attorney how they seek to embrace AI. Um, but there are many, every attorney is doing it differently. They're using it for marketing. Um they're using it to write articles, to produce more articles and produce more educational content, because now AI can actually, if you put in the right prompts and you put in the information that you need, they can, an AI, artificial intelligence AI can write a nice chat GPT can write, a nice article for you, and you can also specify the tone. So a lot of attorneys are using it in that way. There is immigration software companies that are using AI as well to make it easier to write memos, to write petitioner letters, to automate these processes so that cases can be processed faster and can be processed, at a more reasonable cost. So, a lot is being done with reference to AI. Even just responding to emails can be done, right? So more, I can respond to more emails if I use AI, if I use an automated system and keep in touch with my clients. Again, that's marketing. So there are many ways of using AI, I think. And even USCIS, I'm sure, is using AI in many ways to automate their processes as well and decrease their processing times.
So true, so true. And Neha, thank you for your question. Thank you for participating. If you have more questions, you can keep commenting. I wonder where you're from, by the way, and if you're an attorney yourself, let us know. And moving on now to Rajesh. Rajesh is asking, can you walk us through the implications of the USCIS's 2024 policy guidance on the evaluation of O1 visa petitions, particularly with regard to the sustained national or international claim, a claim requirement? And how have you seen this guidance impact the approval rates for O1 petitions?
It's a good question, but I think we'll need an entire session uh, to answer it. But I'll answer it briefly. USCIS is certainly trying to make um, processing of EB1 and O1 easier, and they have, but unfortunately, there's not much they can do in that regard because they have to work within the regulation, and to change the law is a whole different process, which they cannot do without legislative approval. So within what they can do, they're trying to, send out guidance as to and to the stakeholders as well as to officers as to how to approve EB1 cases as well as O1 cases. And as a result of that guidance, they're trying to make the processing of O1s or EB1s easier. So what they're basically saying is, the first thing that they're saying is that there's many alternative evidences that can be looked at. So if a particular evidence is not available for you because you are, say, in a business field, then you can look at alternative evidences. It doesn't have to be, a publication in a newspaper or publication in a journal, or being judged by other people in your field, or it does not have to be letters from other people to show sustained um, that you have sustained extraordinary ability. So they are saying that there are other evidences that are accepted, and if you show us why those other evidences, are just as good, we will accept them. So that's one
Mhm.
thing that they're saying, right? Um, Now, the other thing is with reference to what was the second part of the question? Sustained and
Um, international or sorry, national and international acclaim requirement, and how have you seen this guidance impact the approval rates for O1 petitions?
right. So there was also, if you go back to the previous slide, yeah. Um, Particularly with regards to sustained national or international acclaim. So, with reference to that part, also, they gave some guidance with reference to, uh, that basically saying that not only should you have been doing this work previously, but you should continue to do that work moving forward as well. So, you can't show some work that you have done, 3 years from now, and now you're doing something else and you're not actually doing that work. So it's been a mixed bags. The sustained and national international acclaim has always been there. It's always understood that you have to continue to show that you're going to be that field. So they're just reiterating that. But with reference to uh, the evidences, I think they've made that easier as to what evidences can be given. And I think the reason they've done this is to open up or once to the business field. Ovens were traditionally used in the field of arts and sciences, but not so much in the field of business. And in order to open up the O1 for to the business field, I think there is more policy on that, and they're approving cases if you can show that you are extraordinary ability in the field of business, if you have started a business and grown it in a short period of time, if you have an original idea which you want to implement in the US and create a business here as well. They're trying to, I think, bring in those kind of cases and approve those kind of cases, and I think they are doing them.
Right. Thank you so much, Prashanti, for addressing Rajesh's questions. And Rajesh, I hope you got your answer. Thank you for participating. If you have more questions, keep commenting. We have Vihan now on YouTube asking, I'm working as a software engineer on an H1B visa. I have a much better job offer from a Canadian company. I wish to continue living in the USA. My wife is a US citizen. What all options do we have maintaining the immigration status in the USA while working remotely for the Canadian company?
Can you go back to the first part of the question? I'm working as a software engineer on a H1B visa. Okay, so the person is basically now in the US, but they want to move to Canada because they have an opportunity from a Canadian company. And what's the question after that?
But it's a remote job,
It's
so
a
I guess Vihan will still
it's
be
a
in the US.
Canadian company. I think it's a Canadian company. What are the options do we have maintaining immigration status in the US while working remotely in Canada? So there's no need to maintain immigration status in the US if you're not in the US, right? You cannot. You can only maintain a status in the US while you're in the US. And if you are wanting to file for a green card based on the fact that your wife is a US citizen, then you have to move to the US in order to file that green card if you want to file a 485. If you want to file the green card consular processing, then you can do that while you're outside the country. But if your wife does not establish residence in the US, then as a sponsor, she cannot file your green card as well. So, all in all, I think it makes more sense for you to file the green card while you're actually in the US. And since the green card process for an immediate relative doesn't take that long and there is no visa number availability issue, you should just do that once you come back to the US.
Hmm. There you go, Vihan. I think that makes it easier for you. Thank you so much, Prashanti, for giving Vihan the answer. And Neha's back saying, "No, I'm not an attorney." But she has another question asking, "What all, what all AI technology are you using?" I'm from Houston.
Uh, well, I use a software which uses AI. Uh, so we can talk about this later. I don't know if everybody is interested in what AI technology I'm using, but I did. But
Yes.
yeah, we use a software which uses AI, and I'm using AI in my marketing as well.
Right, right. Yeah, I think that Neha is pretty interested in AI. Thank you, Neha, for participating. We have Shraddha now on YouTube asking, a Mexican entrepreneur who has been operating a successful business in Mexico for several years wishes to expand their operations to the US. However, they are unsure about the best visa option for themselves and their employees. What are the key considerations and visa options for this entrepreneur?
I would say you can apply for a treaty trader visa,
Okay.
treaty investor, which is the E2 visa, or you can also apply for an L1A, intra-company transfer visa. So either one of them. Also, I mean, EB5 could be an option, which is the investor visa. But EB5 takes a long time. So I think the best option would be either the L1 or I think Mexico qualifies for E2. You could do the E2 as well.
Okay.
And what are the
There you go, Shraddha.
considerations? What are the key
Yes.
considerations? The considerations depend on, um, well, whether they want to they want a green card, or they just want a non-immigrant petition. If they want to move immediately to the US, or they want to move sometime in the future, that really makes a big difference with reference to, what kind of visa to choose, and also what will the relationship be between the US company and the Mexican
Mhm.
company. Uh, that also helps, and how much investment is happening, uh, how much they intend to invest. So all these, there are a lot of factors which, uh,
Mhm.
you know, you should take into consideration uh, before you choose the visa.
Okay. There you go, Shraddha. And did I take up all? Okay. I think it's a part of the last comment is a part of the second one also. Let me just put it up. Okay, yeah. Okay, thank you so much, Prashanthi, for taking it up for Shraddha. And now let's move on. I have another question, and this,
Oh, there's Shraddha has the
in
additional
2020.
question. Sorry, Nipasa.
Oh,
She
yes.
says, to
Yeah.
establish a business presence in the US, what are the potential risks and challenges associated with each option? I think we looked at that, as you said, the challenges and risks. It depends on, it's going to be a lot. It's like a half an hour consultation to go through, or a 1 hour consultation to go through the challenges and risks. Each one have their own. For the L1, the advantage
Mhm.
is you get a EB1 green card. E2 disadvantage is that you do not get the EB1. You will qualify for EB2, and you have to go through the perm process, the regular process, which might not be too bad if you're a Mexican, if you're born in Mexico and not an Indian national. Um, and so, each kind of visa, EB5 is taking 5 years, 4 years for them to just process it. But it gives you a green card directly. With the E2 and L1, you have to first, you're first getting the non-immigrant petition and then changing to a green card. So each kind of case has its advantages and disadvantages. So it's important, I think, to speak to an attorney, get a consultation, and then decide, what is the best option for you, depending on your circumstances.
True, true. Every case is different, and Shraddha, it's always best to consult an attorney and be directed, be guided the right way. Thank you, Prashanthi, for taking it up. At this moment, I have this question on our Facebook. I'll just read it out. It says, how have recent court decisions affected immigrant workers, especially in industries like agriculture and healthcare that depend on them? With states enacting, okay, let's take this one first. I think I can ask Control to caption it so that it'll be easier. Um, anyway, I will read it out again, or we can, yeah. Let's quickly go to one of our questions first before we address this one on Facebook. So, in 2024, Prashanti, the Biden administration rolled out new initiatives at reforming the immigration system. So, how did these initiatives directly impact foreign students and workers in the USA?
Reforming the immigration system. Well, I think with reference to foreign students, the H-1B impacts them, correct? Because most foreign students want to remain in the US on a H-1, and then whole multiple registration um, fix that they had allowed more foreign students to apply and get selected under the lottery, because then they were not considering the duplicate registrations. So now it's back to, having a 30% chance of getting selected in the lottery. We talked about new initiatives with reference to foreign students. We don't know what those new initiatives are, as I mentioned earlier. So we have to wait and see um, how that will impact foreign students, or if there is time enough to even implement these new initiatives, because they have not given enough details with reference to what the new initiatives are and how they're going to be implemented. So we have to wait and watch.
Right, Prashanti. Thank you for taking it up. Now let's go back to our Facebook question. And that is, how have recent court decisions affected immigrant workers, especially in industries like agriculture and healthcare that depend on them?
I don't know which recent court cases we are talking about, but I'm not aware of any recent court decisions that came out that affected agriculture, healthcare. I think the only thing is the H2B workers. And with reference to H2B workers, recently they added the visa numbers to the H2B workers, allowing more people to apply. But I think even that has been reached. But otherwise, I'm not aware maybe of any court decisions with affect H2B or H2A workers. Uh, Hello? I can't.
With
Oh, there you go. Now I can hear you.
Okay. Thank you for addressing that, Prashanti. I have another question on our Facebook, and that is, with states enacting their own immigration laws, how do you think the legal battles between state and federal regulations are shaping up in the courts this year?
So states cannot enact their own laws because it's a federal subject. So no one can make laws except for the legislature. So that's the House and the Congress. Um, yes, they can decide how they're implementing the law, meaning that again, immigration, USCIS is a federal body, so they will implement it in all the states, as they should. ICE is a federal body, so they will, whatever they have to do, they will do, um without interference from the states. But if the federal government needs the state to help them with something, for example, if the federal government wants law enforcement to be involved in rounding up illegal immigrants, then the states have a say in it. They may refuse to allow law enforcement to take part in these operations. Um, or if the federal government wants the states to uh, notify them if somebody has a criminal case against them, uh, and so that they can, before they are released, even after they are uh, convicted and put into prison, say after their prison term is over, the states can inform ICE, and ICE can come and pick them up and deport them. But that's up to the state. The states can choose not to do so, and the federal government can force them to do these things, or pressure them to do these things by withholding federal funding. because there is funding that comes from the federal government. So yeah, based on this, we will see. Also, Tom Holmes has been talking about sanctuary cities, states which um, give sanctuary to illegal immigrants and provide them with housing and this and that, and so or are more sympathetic to the immigration cause on the whole. Uh, so yeah, I don't know what legal battles uh, will come out. What will happen if it will go to the courts? I don't think the
Mhm.
courts can force the states to do something that is within their power if they have the power over. If it's a state subject, then that's in the power of the states to decide how they want to do it. So I don't know if courts will really have a say there, uh, but there might be some instances in which the federal government will argue that it's actually a federal subject and the courts must comply. So in that, there might be some conflict there with reference to what is a state subject and what is federal subject, and what that particular issue or conflict falls under, and that might go to the court for them to decide.
Right, right. Thank you so much, Prashanti, for taking that up as well. Now, I think I have one last question, and that is, how did 2024's focus on immigration enforcement in workplaces, such as audits and penalties for non-compliance with I-9 forms, affect businesses and their hiring practices?
So again, there has been a change in the rule with reference to I-9 forms, and they've allowed under the Biden administration the I-9 processing to be done over a video call. Um, so uh, they can look at the person; they don't have to be in person. So that has made things much easier for companies because a lot of employees work remote or they work at client sites, especially in the IT field. And so it's not possible for them to fly to the company's um, address and then present themselves and present their documents. So this has made it easier for companies to comply with I-9. Um, yeah, so I-9 rules otherwise haven't changed. You have to make sure that you meet all the I-9 requirements. E-Verify has not changed. You have to make sure that if you're using E-Verify for one of your employees, then you have to use E-Verify for everyone. So if you're using, you might have to use E-Verify either for students when they're applying for OPT, or if you have federal employees, you have to use E-Verify. So if you're using it for, if you're even one employee that where you need to use E-Verify, then you have to use it for everyone. So you make sure that you do that. With reference to workplace audits, we haven't seen an increase in workplace audits. Last year there was, but usually after the H-1B season, once the cap cases get approved, we do see an increase in FTNS audits. Um, I haven't necessarily seen more FDNS audits this year when compared to last year. Um, but I have seen some pushback with reference to issuing of visas, and they're asking for client letters, etc. So I think
Mhm.
2024 has been more of the same of 2023.
Okay. Okay. Thank you so much, Prashanti. I mean, it was great discussing today, and we touched up on so many topics, and you patiently answered with so much enthusiasm all of these questions I had and our audiences had. And folks out there, I would like to tell you, if you want to have a one-on-one consultation with Attorney Prashanti Reddy, I think you might as well go contact her or email her. And her phone number is 212-354-1010, or you can email Prashanti at reddyesq.com, and also go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy and the law offices of Prashanti Reddy. Thank you so much, Prashanti, today, for joining us and for sharing your invaluable insights and for helping us unpack such a pivotal year, 2024, in US immigration. So it's really always a pleasure to have you and your expertise. Thank you for uh, doing this today.
You're welcome. Thank you. It's always a pleasure.
Thank you, Prashanti. Have a great day ahead, and I hope to see you in the coming Wednesday.
Thank you.
And also to our audience out there, we hope you found today's discussion enlightening and helpful, especially looking back at the year 2024 and a little bit on what can we expect in the coming year, maybe. But we will discuss more on what we can expect in the coming year in our coming episodes. But thank you so much for joining us today, and especially all of you folks who commented and who got your answers. Please do not forget to like, share, and subscribe to our channel. We are Immigration and Jobs Talk Show. Hit the bell icon so that whenever we have discussions like these, you are also notified. And thank you so much for joining us today. So yes, if you enjoyed this session, you also have to follow us on social media. So always a pleasure to be here on discussions like these. Thank you for joining us. This is Nipasa Pradhan signing off for now from Immigration and Jobs Talk Show.